My guest this morning, Jack Okula, an advocate, a policy and legislative expert. I have Moses Kurgat, who is also an advocate, and I have also James Mambole, who's also an advocate, right here with me to discuss that. Very interesting gentleman okay, let me not say very interesting, but I think that's petty. I don't know what you think. I think that exchange between Murkomen and Duale is petty. Let me begin with Senior Murkomen. Moses.
Yes, thank you very much, Bwana Mijungu. The debate, of course, is very interesting in the sense that it has brought out the differences between two supporters of the Jubilee government. And it points out one thing, that even within government, there can be active disagreements. And it points out to how the level of democratic practices that we have in this country, how it has grown, how it has developed. And, of course, we wish to see more of this, where people actively disagree on matters that they should have known how to proceed with them before it reached the level where it has reached. So to some point, okay, I agree with you that it is petty in a way, but of course it has brought out very important aspects of how legislation is supposed to be generated. Okay. Yes.
You don't think it's for drama, it's for television?
Well, I don't think it gives them any credit, especially when right now the political climate in this country requires that those who are in government should be acting in unison, in concert. Yeah.
Jack?
Well, foremost, I do not believe it's a petty argument between the majority leader for the Senate and majority leader for the National Assembly. These are bringing very serious legal issues, serious constitutional issues, and particularly legislative processes, procedures, and development in the House, bicameral House like the one that we have under the Constitution of Kenya 2010. So much as we may consider it as petty, it is not basically for the camera alone. But we also have to interrogate what are the grounds for this disagreement. And I believe that that will bring us to what exactly are the roles of the Senate vis-a-vis the roles of the National Assembly. Okay. And at what level do they need to combine their efforts as far as legislative agenda is concerned. Okay. And whether a bill that ought to go to the Senate, if it went to the President for assent before it goes to the Senate, whether it is law by virtue of it having not passed to the Senate, or whether it can be annulled as the Senate. So I would be reluctant to say it is a petty war. It is a very serious war that every public-spirited Kenyan would really want to look at and probably interrogate, and particularly during this political dispensation where we are talking about a referendum, and whether we can have a relook at our constitution, whether we can also have a relook at the roles of both the Senate and the National Assembly.
We'll be talking about the roles, but the reason why that petty term comes in is because these are two leaders who sit almost in just difference is the stairs to the other person's office, right? And then the exchange, why did you go to State House to stand behind the president to sign? Oh, what have you been doing for the last 6 months? Oh, it doesn't involve you. That's the reason why I'm asking this.
But you see, Ken, yes, there is a difference between personal, how we relate at personal level, and of course the institutions. Remember that the office of the majority leader, Senate, is an institution on its own, and also the office of the majority leader, National Assembly. Yes. So it doesn't matter how Mr. Duale and Mr. Murkomen relate at personal level, but there are also the relationship that exists between their offices, which is formal, which is professional, and which is official. Okay. So at their personal level, they could be petty people, and I believe they are most of the times, but at the level where they are, national leaders holding very serious offices, which is the crust of the working relationship of parliament, there ought to be a way they relate.
Okay. James.
It's a very serious discussion that is, of course, being propagated by very, very petty individuals. These two fellows are, I think, wasting too much time in Tanga. and they are not concentrating fully on the work that is before them. But to say something extremely important, first and foremost, the leaders of majority in both houses of parliament have absolutely no basis at all to discuss these questions, because this constitution is extremely clear that where a matter touches on counties, and at the inception of a bill of the kind that we are seeing now in debate, the speakers of the two houses should sit together and determine whether inside there are matters which touch on counties, for which therefore the two houses of parliament would need to make an input. And after any of those bills has passed through any of the houses, then the speaker is supposed to, of course, send it to the next house for purposes of debate. Now, this is what I have to say. In fact, one of the biggest problems we have had with the implementation of devolution is that the Senate the Senate in the last term was extremely incompetent and inefficient. We thought that it would be better this time, but they aren't doing anything. First and foremost, we shouldn't hear Murkomen making too much noise about a matter that has been passed in the National Assembly. Why didn't he originate this matter in the Senate himself? He waits for the National Assembly to pursue what it believes is its mandate, and then starts making noise. This is what I will say. There is a procedure established by this constitution which allows both houses, led by the speakers, and which would bring on board the majority leaders of both houses and the minority leaders to sit down and agree on formal process on which or through which to process these kind of bills. Okay? It is extremely pretentious that after this bill has now gone all the way and being assented by the president, we turn around and say, no, it should have been done this way. I think I want to insist that, as you said, the offices of these two gentlemen is just a couple of paces away. We do not want to entertain in the public domain fellows who have failed in their respective officialdom, okay, to start making noise using matters that they otherwise should have dealt with in their own capacities in the official sense, and then bring them here. So what Murkomen and his counterpart should do is initiate a dialogue through existing procedures of parliament and have the matter resolved. Because once the president is presented with a bill that has been passed by the assembly,
he has no choice.
He
because even in 14 days it will lapse.
If he thinks it makes good sense,
he will assent immediately.
He will assent immediately. But most importantly also, the other question which we are not being told is we need to see the specifics. We need to look at that bill, or we need to look at that act and determine whether in actual fact right now as we speak, there are matters for which the Senate should have made an input.
But for them even to make noise, gentlemen, it means they think that just apart from the fact that it touches in their commanded in Article 96, they should have had an input, because one, health is not fully devolved but almost 75% devolved. So they feel they need to get it to that.
Our friend Duale has said this matters touch on policy and regulation and so on. We have not had Kipchumba Murkomen telling us
mentioning the
exactly what aspects of that act he thinks. Let me tell you something. Just because a bill or an act of parliament touches on a question which touches, for instance, on a matter that concerns counties, doesn't necessarily always mean that it should have gone to the Senate. Because remember, again, the National Assembly is actually mandated to pass any legislation, including legislation that deals with counties.
It's true. It's true. But this is not a war that began yesterday, Wakili, about the Senate and the National Assembly.
The war has been brewing for a while. And to me, I think it is because of lack of clear understanding of the provisions of this transformative constitution that we have. The provisions that are in place right now enjoins all of us to interpret those provisions in a way that will enhance acceptance by the public, and also to make sure that the institutions that are targeted in terms of the legislation that is being enacted must be involved all the way. In fact, the president cannot just sign anything without also seeking advice anyway from his handlers. I believe that by the time the president was penning his hand into the document, he had already been advised by his legal team to say this is a statute or an enactment that is only concerning policy, which is for the function of the national government and not the county government. But of course, all these parties, you see the squabbles that are in place. I believe that if Murkomen and Duale were able to understand the provisions of devolution under Article Chapter 11 of the Constitution, it would have been very easy for them even to discuss that matter with the president together, because they have access to the president. Why are they going there and they sit there, they sign, do a photo session, and they all look happy, and then they come out complaining? So I believe there must be some level of pettiness that has crept in.
Okay.
Yes.
Okay. And perhaps also playing politics with this.
Yes.
Jack.
If you consider the Schedule 4 of the Constitution, you realize that the functions of the devolved units, more than 26 of them, and of course the functions that are related to the national government, just about 14 or thereabout. Having said that, I've also been involved in the drafting of bills, particularly for government entities, and most of the times you'd realize that that would mean you meet committees from both houses, the National Assembly and the Senate. Yeah. When the committee for a Senate comes, they will tell you, always include this bill concerns counties, even if it does not. The National Assembly would also push that you indicate this bill does not concern counties, even if it does concern county. Now, when you look at the roles, or rather the functions under the devolved units, and there are as many as they are listed in our Constitution, and also the transitional clauses, the Constitution is clear that when we had passed and promulgated the Constitution on the 28th of August 2010, we needed to have reviewed our laws to accord with the Constitution and to accord with the devolution. Now, I do not want to believe that whether it is a matter of policy alone, that it may not necessarily concern the counties. I tend to believe that every other law probably touches on devolution in one way or the other.
Okay.
I like that romantic view of counties, but let me tell you, my friend, this Constitution is very clear, okay? Parliament is divided into two distinct houses, the National Assembly and the Senate, and both of them have been given clear roles to play in this Constitution. Okay. And the framers of this Constitution, in their wisdom, indicate it indicate very clearly, it's not always the case that we must add that lack thereof, indicate the role of the National Assembly to include sometimes because this is the home of national representation. It includes making legislation which touches even on counties, okay? It doesn't say that merely because a matter touches on counties, that Senate must always put its voice, because that is unnecessary duplication. Probably to take it through the process just to agree with what the National Assembly has done. Okay. So I must go back and say that to use the resources of this country appropriately, the speakers of two houses with their respective committees need to sit down, thrash out the issues, agree that this is indeed an issue which touches on counties as spelled out in the Constitution, for which it is mandatory for Senate to give its input. And then once they have agreed, then it is taken through the process. Now, coming later in the day, when a bill has already become an act of parliament, by virtue of assent by the president, and making noise that it did not pass through the Senate as it should have, for me, is grossly incompetent and extremely irresponsible. I want to advise this leadership of parliament that Kenyans are looking at you very closely. And you know, I started by saying that in the last term, the Senate performed extremely dismally because they did not give us any input to assist improve devolution, okay? And I want to tell my friend Kipchumba Murkomen, who is a very good friend of mine, that don't go down that route. Ensure that by the time this term is over, you have proactively led the Senate in doing its job of legislation to strengthen devolution. Do not wait
for the National
Assembly to do something,
yes,
and then start throwing tantrums.
Okay.
That we are not going to accept.
Can allow me to respond to one thing from my senior Mamboleo, with due respect to him. He seems to be gravitating towards the National Assembly too much for reasons that are known to him. But then a few things, we must own up to two things. One, that there are factual issues that we must plead ignorance to. Murkomen says the bill was literally sneaked for the president to assent to it. Murkomen, on the other hand, says, Duale says that Murkomen had the privilege and education to peruse this, and he knew that the health laws bill was also part of the laws that were supposed to be, the bills that were supposed to be assented to. Secondly, that we may not have had the privilege to peruse the health law bills, the amendment bill, for us to know whether it touches only on the policy and what are the contents of this bill. And having said that, we must not appear to be taking sides with one, with only the National Assembly or the Senate. We must now accept that we have a bicameral system where we have the Senate and also the National Assembly, and both have functions. And I agree with my senior to the extent that in the last Parliament, Senate performed dismally. I do not want to believe that the National Assembly did not. They both performed so dismally. More so on there was this conflict between the National Assembly and the Senate,
yes,
which needs to stop anyway. So the Senate has a role to play, and one of the role of the Senate is legislation. And you cannot say that every other law that will go through the National Assembly, once it's assented to by the President, then it becomes law without the Senate having the benefit of looking at it. That I do not want to agree with.
Okay.
Just one point.
Go ahead. Yeah.
In our Constitution, I think it is provided very clearly that the National Assembly and the Senate are enjoined to consult regularly on matters that are happening. These two institutions are not in different countries of the world. They are here. They are actually sitting next to each other every other day, and they meet during lunchtime, during sessions, they crisscross the floors. So I think it's a matter that requires them to look back and say, where do we start? When you want to implement the Constitution, you start from the very first chapter of the Constitution. These functions are functions that have been bestowed on you by the people of Kenya. So you must always act in the interest of the people of Kenya. You are an agent of the people of Kenya. So when they squabble like this, of course, the shame is brought to both institutions. That is my point of view.
Okay.
And I would want to see them now change tact and fold and say, let's consult before we go public.
Okay.
Because this is failing to understand.
But Wakili, you have to agree with what Mamboleo is saying.
No, I do agree, but to a point that we should not apportion the blame to one institution.
What he's saying is that the Senate should be proactive and stop reacting.
Exactly.
Actually,
yes.
Ken, Article 113 of this Constitution creates mediation committees.
Yes.
Should there be a problem with a bill such as this,
Okay.
Murkomen and Duale can move the speakers of both houses and say, hey, wait a minute.
Yeah.
This bill, even though it has been passed by the National Assembly and given to the President for assent, can actually be relooked at because it had a matter for which the Senate needed to make an input. Okay. And they can sit down nicely like gentlemen and discuss that matter. But that doesn't take away a cardinal point which I want to make, which is this. Let Senate be proactive and assist counties, because if it keeps waiting for the National Assembly to pass legislation so that it can react to it, you can bet that the National Assembly, every time it goes to legislate, it is not always going to have the Senate in mind. And so therefore it's not going to play the role that Senate is supposed to play. They should get into the thing, play their role, and stop throwing tantrums.
All right, we're coming back because we still have to discuss the roles, the active roles of the National Assembly and the Senate. But let's bring back the discussion here and talk about that quagmire in legislation and the fact that the Senate and the National Assembly don't seem to be seeing eye to eye, in spite of the fact that they should be working together. They look like they're working for a different government, different people. And the lawyers here in the House join me to discuss this. And at least I want to give you an opportunity, Moses, to finish what we were saying, because we need to discuss the specific responsibilities of the Senate and National Assembly, Article 95, and look at the reason why there are these overlapping roles, right? So, yes.
Thank you very much. In fact, if Parliament and the Senate had understood their roles, which are provided for in Article 95 and 96 respectively, this kind of problems we are witnessing today would not be there. In fact, we would be having a very smooth flow of legislative agenda in this country. The roles that are set out, in fact, the easiest role, in fact, in future, if I was to become ambitious and become a politician, I would want to be a senator, because I've got only one single function: to protect the interests of the counties. And the county interests are varied. It is like a national duty. You are covering every part of the country. You have the responsibility to make sure that the agenda for devolution is kept up to the required standards. You are required also to ensure that the legislations that concerns the counties are passed expeditiously, and also help the countries to grow. We are seeing the counties in this country today having problems, for example, in getting the county attorneys in place. They don't have good structures to help government, the various governors, to develop systems and to legislate at the county level, at the county assembly level. So it is the duty of the Senate to ensure that all these functions that are given to them under Article 96 are implemented. And of course, when you fall back to Article 95, which has more responsibilities to the National Assembly, apart from taking care of the issues concerning the finances, the funding, and everything as appropriation of funds to the national government, they also have to take care of the concerns of the people of Kenya, which includes what the senators do in terms of protecting the country. So you can see there is an overlap between the functions of the National Assembly and the Senate.
But how comes there's an overlap, yet the Constitution is so clear on this role?
No, the overlap is actually alluded to by the Constitution itself. It is not like it's an overlap that is causing any friction. It is meant to be smooth flowing.
The Constitution is not clear, has never been clear. The premise of the Constitution, in their wisdom or lack thereof, Wakili does not want me to say that, says that the National Assembly, under Article 95, will deliberate on matters that concern the people. The question is, who are the people? This is such ambiguous provision. Who are the people? Does devolution entail the people?
The same people. Yes.
I think that's what I'm saying. The Constitution is clear.
Yes, there is an overlap. And part of the reason I asked to confess that I voted no for the Constitution is this ambiguity in its provisions, particularly on the roles of the Senate and the roles of the National Assembly. When you talk about deliberating on matters concerning the people, when you talk about a bill that concerns devolution or concern counties, it also concerns the people. So is the Senate also mandated by the Constitution, already at the provision of the law, to deal with matters that concern the people? Or when it concerns the county, does it mean it does not concern the people? Now, when you look at Article 95 and Article 96, that is the role of the National Assembly and the role of the Senate, and Senior, I encourage you to your ambition is valid, that you can become a senator. The only problem is you will even find it difficult to define what your role is, because there is really no role for the Senate in the Constitution. Because even the bills, even the legislations that can concern the counties, the National Assembly still deliberate on them. As a matter of fact, the National Assembly deliberate on virtually every other bill, any other law. And I realized that the Senate and the National Assemblies, they always have conflicting sessions. Right now, the Senate is in session, and the National Assembly is off session until probably up to around next month. How do senators know that the National Assembly are now deliberating on such a law? So there is a gap.
But
Is
they
there-
have the speakers who should be speaking.
that is what I was getting to. Is
Yes.
there a speakers forum? Because the level of engagement should be that of cooperation and that of consultation. Do they consult? The majority leader for the National Assembly, majority leader for the Senate, and the speakers of both houses, do they consult and know which laws which house is deliberating on, and what kind of engagement and what kind of participation do they need for which house?
Okay.
Ken, just before Mamboleo comes in,
Yes.
If you look at Article 94 of the Constitution, it talks of one parliament.
Yes.
That parliament includes the National Assembly and the Senate. And all of them serve the interests of the people of Kenya. So in essence, I think I would beg to disagree with Kula when it comes to the defined roles of the Senate as not being clear. They are actually clear.
Senior,
Yes, yes.
Senior, don't beg to disagree with him. You should disagree with him fully. Ken, I am extremely amazed at the amount of conjecture you are allowing my colleague to pass on national television. It is important to read provisions of the Constitution in full.
Not jump to one.
What my colleague is alluding to is sub-article 2 of Article 95, which says that the National Assembly deliberates on unresolved issues of concern to the people. And then Article 95 has many other provisions downwards,
Including the major one on 3.
which lay down the role of the National Assembly in black and white. And then Article 96 now lays down the role of the Senate very clearly. Let me tell you something. The reason why the members of parliament in Senate and members of parliament in the National Assembly don't perform their roles properly, just like the two speakers, is because of the amount of cobwebs that they have in their heads. It's because in the first place, we don't even have the right people in those houses.
Really?
This constitution at Article 94 defines the role of parliament. And I want to invite members of parliament to read this constitution. 94 defines the role of parliament as a whole. And then 95 lays down the role of the National Assembly. And of importance, which I need to put out to the public, is that the National Assembly is the most representative house of the Republic by virtue of the fact that the National Assembly carries people from smaller units called constituencies. It is the heartbeat of the nation, so to speak. And so, because of that characteristic, the framers of this constitution have given it a wider role than the Senate. And it allows the National Assembly to debate on literally any question they want to debate in, including questions which touch on on counties.
Yes.
But then, because it recognizes the fact that there could be special issues which relate to counties, it has given a very clear list of issues on which the Senate can deal with under Article 96. But now, I don't want to read for you Article 96. I want you to go and look at Article 112, which says what matters you would characterize or categorize as county bills. Okay? So the speakers of both houses, together with the leadership of the assembly, need to sit down and look at what exactly is a county bill, or a matter which touches on counties. But the most important thing, which is the important thing that Kenyans should take home, is that the speakers of the National Assembly are sleeping on the job. The Speaker of the National Assembly and the Speaker of the Senate are sleeping on the job. The leadership of both houses, majority and minority, are also sleeping on the job. The House business committees of all these houses are also sleeping on the job, because this constitution creates a framework in which every time a matter comes before the House, these people are supposed to sit down and thrash out the issues. Say, this is a matter which touches on counties, this is a matter which doesn't touch on counties. This is a matter for which the Senate would be required to give its input, and this is a matter for which it does not require an input. They can even agree that this is a matter on which the Senate would have been given an opportunity to give an input. But we think that the way the National Assembly has dealt with it is actually fine. So we don't need to duplicate that particular process. Okay? So it doesn't have to be always the case that because a matter touches on counties, that it must go to Senate. The leadership needs to look at it and say, well, it touches on counties, but the National Assembly has done a good job of it. So let it go to the president for assent.
Okay.
So what is happening today, Ken,
Mm.
is a scenario in which people have refused to sit down at their desks and do research and
Okay.
do the right job.
Okay.
And then because they can't do that job, they think it is easier to quarrel in public. And because the media is there to give them the space, then they are willing.
So that's
to
what they do. That's what they're doing. Yes.
Again, there's something that I wish to add on what Mamboleo has said. The structure of the Senate and the people who work under the senators, the technocrats, the advisors, are the ones who I think are failing the senators and the members of the National Assembly. Because they need to be given timely advice, they need to be given correct interpretation of the Constitution, and this one is shown by the way the comments that were exchanged between Murkomen and Duale. It shows exactly what happens, that these people are not in touch with their technocrats who are advising them, because these are politicians. They don't have time to research. Of course, it is a lie that they shouldn't have time, because we've seen senators in the US who do extremely good researches to support their point of view when they are propagating issues concerning the citizens of their country. So the same thing should apply here. So we need, we have a duty here as commentators, as readers of the Constitution, and also people who can influence the processes, to advise our members of parliament that it is important for them to seek proper interpretation of the Constitution before they open their mouths, because what they have done here is embarrassing, because they can do better. They can do
And
better.
it's true that they can do it, because I know senators and members of parliament who actually do the job. I can mention names. For instance, the senator from Makueni, Honorable Mutula Kilonzo Jr., does a fantastic job. Anytime you see him making a presentation on anything, he has done his research properly, and he will not be speaking off the top of his mind. We expect that, especially senators who are lawyers, advocates of the High Court of Kenya, to come with a presentation on facts. In fact, you had the governor of Nairobi here the other day, and I was impressed at the way he brings papers and gives documentary evidence on each and everything he says. So we expect these people to, each of them, say, yes, this is the bill, this is the aspect which touches on counties, this is the way Senate would have put an input, and by now we should have been expecting a memorandum from the office of the majority leader of the Senate, saying that the problem
is this. Exactly.
Laying down the specifics.
Okay.
Now, that one we could be discussing, because then it means that someone has applied his mind to the process.
Okay.
Otherwise, this is political.
To that extent, I agree with my senior. To the extent that you will need a memorandum, a proper research, and as a drafter, because I understand and I know he's drafted a number of legislations before for touching on counties and so on and so forth. And you look at the article 110 all the way to 113, you realize there are different types of bills. Like there is the money bill, there are bills that touch on, that concern counties. And what are the bills that concern counties? Are bills that touches on the functions of the counties or the devolved units as per Schedule 4 of the Constitution. Now, it doesn't matter what the title of that bill is. You really have to look at that bill word for word, full stop for full stop, comma for comma, every other provision in it, for you to be able to understand, even if it is a word, even if it is a full stop that will connote that it concerns counties, Senate needs to look at it. So I agree to the extent that the majority leader, probably of both houses, and the speakers of both houses are sleeping on their jobs.
Okay.
And I stand on my point that the roles of the Senate and the roles of the National Assembly, there is really no clear contradistinction. Because when you look at Article 95 and of course 96, it's talked about just one provision, and which I quoted, but even other provisions. It's talking about National Assembly looking at bills that concerns revenue. The division of
I'd like to
revenue
talk
bill,
about division, because that has caused a lot of heat.
that is also a role of the Senate anyway.
Yes,
because it is it's a revenue bill. It is both a role of the National Assembly and a role of the Senate. And you look at the role of National Assembly, foresight, oversight of state officers like the president or the deputy president, it is also a role of the Senate.
Yes.
So when Parliament, as it is, and under Article 94, you look at the roles of the Parliament. One is oversight, representation, and legislation. So when you come to 95 and 96, there is really no clear contradistinction between because the only contradistinction is considering bills or laws that concerns counties. But what are these bills or laws that concern counties? You have to go to Schedule 4 to know whether this is a function of the county. And for you to know that, you will also have to look at that bill word for word for you to know whether there is a provision that touches on the functions of a county.
I'm going to look at one specific kind of a bill, an ordinary bill. I like to look at Article 112. But before then, plainly speaking, from the three of you, plainly speaking, if a bill would originate from the Senate, any kind of a bill, would it still need to go to the National Assembly? Or there are bills that are specific to the Senate and should not go to the National Assembly? And the other question is, any bill, forget about the specific bills that we talk about, would originate from the National Assembly. Does it have to go to the Senate? So the thing is, the Senate and the National Assembly, what kind of relation do they have? Because there is this, that some bills that originate from the National Assembly are so important, unless they touch on the Senate, that don't have to go through the Senate, they go straight to the President. However, bills that originate from the Senate are not so important. However, they must be looked at by the National Assembly. Plainly speaking, I don't want to go to the law first, because I'm going to go to that specific bill. Just the three of you, from the top of your mind.
Let me clarify on something. You see, for the longest time, there was a struggle about allocation of resources. Many in the yesteryear of the fight against centralization of resources were of the view that it was important to devolve some of these resources to far-flung areas of this country, to have the decision on how this money is going to be spent made there as opposed to here. And this constitution is extremely clear on that question. This constitution at Article 95 states that the National Assembly has the responsibility of allocating resources between the two levels of government. What does that mean? That it is the responsibility of the National Assembly to determine that the counties will get this amount of money in total this year, and the national government will get this amount of money this year. Okay? That is their sole responsibility. Now, at Article 96, the Senate has been given the responsibility of determining how the allocation that they have gotten for counties from the National Assembly is going to be distributed amongst the counties, the 47 counties of the Republic of Kenya, with working together with the other structures existing. They need to determine that this is the amount that will go to Kiambu and this is the amount that will go to this place. What I told you earlier, there is supposed to be a committee of the speakers of the National Assembly encompassing the leadership of the two houses. And from the very beginning, if it was working properly, they're supposed to determine that this is a matter for which the two houses are supposed to be appraised.
Yes.
And once they decide that, and if they decided that it will start at the Senate, it can start at the Senate and end at the National Assembly,
yes.
And vice versa. Okay? Or this is a matter probably which we need to, it has questions that touch on counties, but let the National Assembly do the job first, and once it is done, we will review and see whether the Senate needs to give an input. Or whatever it is, let the two houses be appraised of it. So let us not look like small children. Let us do things systematically, methodically. The procedures are there. Create them. Even where this process has not been followed, I told you earlier, there is a provision for the establishment of a mediation committee.
Yes.
They can sit down and say the correct procedure has not been followed. So let's go back and look at how we can remedy that situation. That is what we are supposed to do.
You've gone straight to Article 112.
Yes. The mediation committee is only invoked whenever there is a problem, such as there is a problem now. But remember, the health law bills has already been assented to by the president. So the only remedy probably could be to seek judicial interpretation. having said that, I want to answer your question by asking
What they're
another
not going
question.
for, they're going for annulment of those laws. That's what the Senate said.
How will they do
I
that?
don't know, but that's what Molkomen, who's a lawyer, by the way, said.
What I'm saying is that how would you know that a bill concerns counties if you don't read it, if it does not go to the Senate? So my proposal would be that every other law goes to both houses, both to the Senate and to the National Assembly. They interrogate it first. If both houses interrogate it and find there is some provision that probably touches on the counties or the functions of the counties, then it can also go to the Senate. So to answer your question, ought laws, or do we have a situation where every other bill goes to the two houses? The answer is in the affirmative. The question whether all laws need to go to the Senate, the answer is in the affirmative. Otherwise, you would not be able to know whether it concerns counties.
Okay.
And then there ought to be a committee comprising of the speakers of both houses, the majority leaders, and probably the minority leaders and the whips of both houses, so that they look at the bills, whether it originates from the Senate or the National Assembly, to know whether it is a bill that needs to be interrogated by the two houses. Otherwise, if the National Assembly passes a bill, in their wisdom or lack of it, and it does not go to the Senate, later on, after it's been assented to by the President, it is when it is discovered that this law touches or concerns a county.
Okay.
What is the repercussion? What is the remedy for that?
Okay.
Yes.
Very, very interesting.
Yeah, I think just to add on what my colleagues have said, to me, I'm seeing the element of tough wars between the two houses. There has been discussion in the past about whether there is need for us to retain the Senate or not.
Yes.
And I think maybe this is the culmination of that, and the two members of parliament were not able to bring it out. I think there is a feeling, general feeling, that maybe the Senate, coupled with what my colleague has said, that the Senate doesn't have clear roles. Is there a need for this Senate to exist beyond where it is right now?
Okay.
My view is this, whatever it is, the situation, we need to find a solution to the current issue. And the solution lies in the Constitution as it is right now.
Okay.
The Constitution that we have is very elaborate. It has solutions or means of finding solutions in situations that are necessary. So I think it is a question of Parliament now sitting together, the two heads of the two houses, that is the Speaker of the National Assembly and the Speaker of the Senate, putting their heads together with their technocrats and finding a way of advising their respective members of Parliament so that they can find a solution.
Okay.
Because we don't want to see this
happening. We don't. The good thing is, almost the first time we're seeing it, apart from the fact that the time they had the issues, the division of revenue bills.
Yes.
I think my senior colleague has raised something extremely important, and the historical foundation
Okay.
of a bicameral parliament.
I'm told we're going to come back because we were on standby for the first press conference of Cyrus Oguna, the new government spokesperson, but we're coming back with this conversation. Let's bring back the conversation. We have a report on the ground, so that story will be broken down to you later, so you're not missing anything as we continue with our conversation. We have a few minutes, gentlemen, to finish this conversation, so I'll allow you to finish because I cut you short, then we can conclude this discussion.
Yes, I wanted to say that the presidentialist system from which we have borrowed the bicameral parliament structure is the United States, basically. And in that system, the Senate is structured to be the superior house to the National Assembly. Yes. So with very clear step-by-step process on how for any legislation to become law needs to pass through the two houses, and the categorization is extremely clear. Now, that is exactly what I would say is a challenge with the constitutional dispensation we have, where we have a parliament in which the framers of this constitution did not give any of the houses superiority over the other. In fact, commentators only agree that the National Assembly could be superior to the Senate, which is an abnormalcy in terms,
yes.
Because of the role that the National Assembly has been given, rather than a clear express connotation in the Constitution itself that the National Assembly is the superior house. So what needs to happen is that both speakers of the House, with their teams, need to understand that in the context of the Constitution that we have, there is no House that is superior to the other.
Okay.
In fact, the framers of this Constitution anticipated a very elaborate process in which, right from the very beginning, the leadership of the two houses sits down and they agree on how the business is going to be done.
Okay.
We are not going to like the disjunctive manner in which these two houses are operating.
Okay. Yes. Wakili.
Thank you very much. I think it is time for all of us to have a relook at the Constitution to see whether we can help the two houses find sense of direction. In my view, the provisions are very clear. There is nothing that creates any conflict as such. I think it is a question of interpretation and innovative advice being supplied to both houses in order for them to find sense in what they are doing. There is need for us as people who look at Parliament from outside to give them the correct advice, and I believe they are listening now, that they should know that the so-called divisions that they have are not sanctioned by the Constitution in a manner that can make them feel inferior or superior to each other. They are all equal and they serve. One happy thing is that they serve the people of Kenya. None of them is serving animals. They're all serving the people of Kenya. And the people of Kenya are one.
Okay.
Whether they are in a constituency or in a county or in a combination of various counties. They are all comprised of people of Kenya. So it's a question of looking at it. How do they serve the people of Kenya? Do they understand what the term the people of Kenya mean?
Okay.
Because I think that is where the problem is. Because they should understand that they are all serving all the
across
people of
the
Kenya.
board, across the board,
Yes.
regardless of where they sit.
Yes, yes.
All right, we have about 4 minutes. So, Jack, as you comment, I also want you to comment about a possible remedy just in a minute that the Senate has in the fact that now the law has been passed, the amendment has been passed, and they're saying we'll go to court or we will succeed in this. So, as your closing remark in a minute, you mentioned that also.
Well, let me just start with that. The moment the law has been assented to, it's become law. And probably in not too distant days from now, it will be operational. So the only remedy for them would be to seek judicial interpretation. And by they have that right under the Constitution to seek any judicial interpretation. They can still go to court. Any other Kenyan can go to court. It's not restricted by any law not to go to court. But for the law to come back to the House, that of course would be a nullity. It cannot work that way. So the only remedy for them is to seek judicial interpretation.
Okay.
Having said that, the drafters of our Constitution relied heavily on other systems, like they were trying to borrow from the UK, where we have the legislative supremacy, and also from America. My colleague has talked about that. But the only problem was that even as they were borrowing this, they did not put measures in place or other provision. It's a travesty to even imagine that the Senate is the superior house simply because of the number of people who elect the senators. It needs to be in the law. Not that when I'm a senator for Migori County, I represent 8 constituencies, but doesn't make me more superior to you, Ken, if you represent Uriri constituency, which is within Migori County. It needs to be in the law that the Senate is the superior house, or the National Assembly is the. But what happened is that the major politicians, or the senior politicians in the 10th Parliament, was it 10th Parliament?
Yes.
Yes, 10th Parliament. Interfered with the Constitution. They said, okay, fine, we are going to make Senate the superior house, but also not give it so much roles anyway, because we are now senior politicians. We need to exercise more power, but very few roles. But they did not really succeed in that, because when you look at the functions again, you might be persuaded to imagine that the National Assembly is more superior to the Senate, given the roles that it exercises. But that is not supposed to be. In my very radical...
You need to finish. They have a minute each.
Very radical, learned opinion.
Yes.
We need to disband the Senate.
The Senate. That's a discussion for another day. Wakili, you have less than a minute.
I don't think it is time to disband the Senate. My view is that we need to find space for proper interpretation of the law to allow the two houses to operate without a problem.
Okay.
That is my view.
Finally,
I will add my voice by saying that I want to request the leadership of the Senate to live up to its role by proactively looking at how best it can initiate legislation to assist firm up the gains we have made for devolution, and then secondly, play their oversight role over counties appropriately. The other day, I had the chairman of one of the Senate committees announcing in a baraza that, you know, if a certain governor doesn't come to the Senate, atabeba msalaba waka, and so, and I was asking myself, now, what kind of Senate is this? If he doesn't come, if the governor is summoned to Senate and he doesn't come, there is clear legislation or process by which remedies can be had against him. So we want to take away this ngeta mentality that we have in members of parliament, mob justice and so on, and have people who are sitting at their desks, exchanging emails. These days there is even WhatsApp. They can be talking continuously to assist create a better parliament.
All right, so on that note, thank you, gentlemen. James Mambweleo, Moses Kurgan, and all the best, by the way, for that position. Yeah. All the best. And Jack Okula, thank you very much for coming. I'll be back at around 1 p.m. Not around, but at 1 p.m. with an update of all the stories you need to know at that hour. And well, after this, Edvis Sasa is on air. Good morning.